Welcome back, everybody, to SEC Roundup. My name is Tom Zucchero. I'm a partner in Paul Hastings' White Collar and Investigations Group. With me today, as always, is my partner, Nick Morgan, also from Paul Hastings. Hi, Nick. How are you?
Hey, Tom. Doing well, thanks.
We're honored to have Professor Antony Page. Professor Page is a dean of Florida International University College of Law, which is the only public law school in Southern Florida. Professor, very happy and honored to have you join us today.
Hey, thanks very much for having me.
Our pleasure. So we're going to talk about a regulation that we don't talk too much about, Reg FD. Reg FD was adopted by the SEC in 2000, many decades ago. And the concept behind Reg FD was the commission was concerned with corporate executives giving material non-public information to analysts and institutional shareholders before disclosing it to the market generally. They wanted to prevent selective disclosure. So we don't see that many cases involving Reg FD, but there's one recently in the Southern District of New York, which was generating some interest. Nick, why don't you talk a little bit about the regulation and about the recent case?
Sure, Tom, and you're right. This is pretty unusual, not only because the SEC doesn't bring very many Reg FD cases at all in recent times, but the number of litigated Reg FD cases is vanishingly small. So this is quite unusual. They brought the case March of 2021. It's sort of been percolating along, and the parties, the SEC and the defendant, filed cross motions for summary judgment some time ago. And so the development is that the judge denied both sides cross motions for summary judgment, so the case will go to trial. And in a nutshell, I mean, the fact pattern is not that novel. The company had been missing consensus estimates for some period, and so in a particular period, the allegation is that some of the company personnel communicated to analysts material non-public information about revenue that, as material non-public information is, it had not yet been disclosed to the public. So that's sort of the factual scenario in a nutshell. And, we're going to, presumably, if the parties don't settle, we're going to see a trial in the Southern District of New York over this Reg FD issue.
So, Professor, let's turn to you. You've written an article some years back challenging the constitutionality of Reg FD. Tell us about your view on the constitutionality of the reg, and has this case and the judge's decision in any way affected your thinking?
Well, no, not really. It hasn't affected my thinking. I did read the case, all 100 and something pages of it. And frankly, there's a fair bit in the opinion that I actually really like. So to start with, the judge takes the constitutional challenge seriously, which is great. And specifically the idea that this regulation does in fact violate the First Amendment. He wrote 27 pages addressing this argument. And, 50 years ago, he wouldn't have done that. 50 years ago, the idea that the First Amendment would apply to securities related speech of a corporation, it just wouldn't have got any attention at all. So I'm pleased that he's taken it seriously. I also like the way he acknowledges that none of the existing First Amendment frameworks for analyzing regulations, none of them are a satisfying match for this regulation. And that's something that I think came through in the article, which I actually co-authored with an ACLU lawyer back in 2005. None of them provide a satisfying match. So I completely agree with him there. And the reason for that is this is an unusual regulation because it either prevents or burdens or compels speech. And there are few, if any, regulations other than Reg FD which does that. Yeah. Third thing that I really like about it, he completely rejects rational review, which I completely agree with. So rational review, of course, would have meant the SEC wins, no problem, very easy, very quick, we can all go home. And he rejects that standard of review. Now, he also rejects strict scrutiny, which is reasonable. I mean, I would argue that strict scrutiny is appropriate, but it's certainly far from a slam dunk. So he goes ahead and applies intermediate review. And the joy of being in intermediate review is it's not outcome determinative. If a judge is going to apply intermediate review, it's going to depend on the judge and on the facts far, far more. Now, I should also note this is an applied challenge. So it's specifically with respect to what the defendant actually did, the defendant's actual speech, which here, as the judge puts it, it's just prosaic performance data. It's just boring facts. It's nothing that's the more exciting kinds of speech, political speech, for example, which would more squarely fit within a strict scrutiny framework. So I appreciate all those things about this particular decision. Now, where I disagree, not surprisingly, is with the actual application of this intermediate scrutiny test. And here, I think the judge gets it wrong. Specifically, the judge seems to ignore the possibility that Reg FD could affect political speech. And I absolutely think it could. I guess another part where I would sort of take issue is it really is a pretty lax application of intermediate scrutiny. And I would have preferred to see a more rigorous application in terms of what the SEC is actually trying to accomplish. And what we have here, it's not, I hasten to add, it's not the selective disclosure per se that's bad. It's people trading on it. That's the harm. It's insider trading. That's really what it is that the SEC wants to stop. And all of its justifications all depend upon trading. And yet the rule itself specifically targets speech. It's got nothing to do with whether there is any trading or anything else that's actually going on. So in that sense, it's really sort of misplaced. If you don't like insider trading, target the insider trading. Now, we know that under 10b-5 and the way 10b-5 evolved and how the Supreme Court limited 10b-5, that wouldn't be easy for the SEC and might actually require congressional action, but that would clearly be a better world to live in where we actually targeted the specific harms. And, as my paper goes into in, frankly, quite extraordinary detail, Reg FD is really ill-suited. It is under-inclusive and it is over-inclusive, given the real harm that the SEC is trying to address.
Yeah, well, that's an amazing analysis of the case and the constitutional issues. I suppose the Second Circuit and maybe even the Supreme Court may ultimately weigh in on this, and we'll just have to wait to see what happens as this case progresses through the judicial system.
Absolutely. And I guess, sir, one other thing to note is that since I wrote that article, the Supreme Court has been more sort of sympathetic to the idea of a corporation as a person. We've had Citizens United, we've had Hobby Lobby, and the courts seem willing to treat corporations more person-like. And that could also inform an analysis.
Yeah, that's a great point. Professor, thank you so much for your time. This is really a very insightful analysis. Nick, thank you as always, and we'll see you all at the next SEC Roundup.
Thanks very much.